In this lecture, I will discuss the topic of bringing on record legal heirs of the deceased dependent, and I will discuss this topic with reference to Article 137 of the Limitation Act of 1963 and Article 120 and Rule 4 of Order 22 of the Civil Procedure Code. Especially, I am giving emphasis on this Article 137 of the Limitation Act in this topic. Relating to this topic, I have already uploaded 2 video lectures. First is regarding introduction of legal provisions for bringing on record legal representative of deceased parties in the suit. And second video lecture is relating to Article 120 and Article 121 of the Limitation Act of 1963. So I request you, all of you, please also watch those my earlier 2 video lectures. In this today's topic, I am discussing this topic with reference to one judgment of the Delhi High Court, reported judgment. It is reported in the All India Reporter, year 1972, Delhi, page 253. This judgment is given in the civil revision petition. The parties before the High Court are Shrimati Kailash Kapoor versus Naresh Chandra Mishra. Shrimati Kailash Kapoor is the petitioner before the High Court. Naresh Chandra Mishra is the respondent before the High Court. The facts of this case is that Naresh Chandra Mishra, who is plaintiff in one suit, who is the original plaintiff, Naresh Chandra, he filed a plain suit for recovery of money advance against one Nanda Gopal. So it was the contention in this suit filed by Naresh Chandra that he has advanced some amount to Nanda Gopal, but that Nanda Gopal did not pay back that amount to the Naresh Chandra as agreed or as promised. Therefore, this Naresh Chandra filed a suit against that Nanda Gopal, to whom he has advanced money and who has not refunded that amount. That suit for recovery of money advance, this suit was filed in the year 1966. So in that suit before the trial court, Naresh Chandra, who is respondent here before the respondent here in this revision petition before the High Court. So Naresh Chandra is the plaintiff and that one Nanda Gopal was the defendant. When that suit was pending, that Nanda Gopal died on 2nd February 1967. He died on dependent, he is the sole dependent in the suit. Nanda Gopal is the sole dependent in the suit. He died on 2nd February 1967. Therefore, to bring the legal representatives of that this is Nanda Gopal, this plaintiff Naresh Chandra filed an application before the court on 26 April 1967. As we have already seen in our earlier lecture, as per the Article 120 of the Limitation Act, period for making such an application is 90 days from the date of the death of that deceased party. So here plaintiff has made this application on 26 April 1967, that is very well within the limitation period, because the deceased sole dependent died on 2nd February 1967 and plaintiff has filed an application on 26 April 1967. In that application, plaintiff mentions the name of 6 persons as a legal representative of their deceased dependent Nanda Gopal. To that application, Mrs. Nandagopal, that means that widow of Nandagopal, she opposed the application. She opposed the application of that plaintiff on the ground that she said that in that application filed by the plaintiff, the name of those 4 persons in that application, those 4 persons were not the children of the deceased Nandagopal. So that plaintiff has mentioned the name of 6 persons to that application. That widow of Nandagopal raised the objection. She said that out of the 6 persons, the name of 4 persons are incorrect because they were not the children of that deceased Nandagopal. Only 2 persons are correct. But while raising such an objection, making opposition by that widow of Nandagopal to the application of plaintiff, she did not state in her reply, did not state clearly how many children are there to them, that this is Nandagopal, and she was not clear that in her reply that her own name is Kailash. Her own name is Kailash Kapoor. The plaintiff was not knowing her name. Plaintiff was not knowing actually the name of that widow of deceased Nandagopal, and she also didn't tell her own name that her own name is Kailash Kapoor. This Kailash Kapoor is here petitioner before the High Court, Srimati Kailash Kapoor, who is a widow of Nandagopal. Then, again on 5th September 1967, plaintiff again filed one replication stating that from where he get to know the name of those 6 persons as a legal representative of the deceased Nandagopal. So, in that application, plaintiff said that he made all possible efforts to find out the names of the legal representative of the deceased Nandagopal, and the only source from which he could collect the names of the legal representative was the ration card of the family of the deceased. So he said that whatever names were mentioned in that ration card, he mentioned all those names in his application as a legal representatives. But reality may be different, because in that ration card there are also the names of some other brothers of the deceased Nandagopal. That means those brothers, they were not the actually legal representatives, because they were not the children of the deceased Nandagopal, but they were brothers of that Nandagopal. But plaintiff was not having any idea what is the relations of those person who is named in the ration card with the deceased. So he made a mistake by bringing those 4 other names as a legal representative of deceased Nandagopal. But he has made bona fide and honest efforts to find out the names of legal representative of the Nandagopal. He also prayed that before the court in his replication application that widow of deceased Nandagopal may be directed to disclose the correct names of all the legal representative of the deceased Nandagopal, but she has not disclosed. So that application, which was made by the plaintiff within the limitation period for bringing the legal representative of deceased dependent Nandagopal, so there were only 2 persons are real legal representative of the deceased dependent, but other persons were not known to the plaintiff. That means that application is restricted to only 2 years of that deceased dependent Nandagopal. But there were also some other legal representatives also, of whom this plaintiff was not having the knowledge. Then that plaintiff tried a lot, but he didn't get the names of other legal representatives of the deceased Nandagopal. Therefore, in the state of helplessness, he made a statement before the court on 24th February 1968 that plaintiff, that advocate for the plaintiff made a statement. Advocate for that plaintiff Naresh Chandra. Plaintiff is Naresh Chandra, who is a respondent here before this High Court. So that advocate for the plaintiff Naresh Chandra, in the state of helplessness, he made a statement before the court on 24th February 1968 that he gave up means sacrifice. He gave up the claim against other legal heirs because their names and address were not known to him in spite of his best efforts to find them. So he made such a statement. In fact, he need not to have made such a statement, but he made such a statement. Then on the basis of that statement, again, on the next date, that is on 4th March 1968, that widow of deceased Nanda Gopal and one of her son, who were already brought on record as legal heirs, they filed further reply before the court stating that the plaintiff sought to bring on record only two legal representatives, that is that widow Srimati Kailash and one son, his name is Vikram. Only two legal representatives, but there are other legal heirs. There were other legal heirs also to that deceased. There is one more son and two daughters, married daughters, and it was the contention of that widow of Nanda Gopal, that is Srimati Kailash, that other legal heirs could not be dispensed with, as the suit could not proceed in their absence, and therefore suit should be dismissed as having been abated. So she made a statement that suit should have been dismissed as having been abated because plaintiff has not brought other legal heirs on the record. Then again, this plaintiff made a replication to this reply made by that widow of Nanda Gopal, Srimati Kailash. Plaintiff again filed a replication stating that he said that Mrs. Nanda Gopal gave a reply that deceased Nanda Gopal left behind him two sons and two daughters, but she did not disclose the names of all these two sons and two daughters. Therefore, he was not able to get correct names and particulars of all the legal representatives in spite of his best efforts, and therefore it was his plaintiff's contention is that suit could not be said to have been abated. Okay, so far there were only two legal heirs of the Nanda Gopal, deceased dependent Nanda Gopal on record, and other legal heirs were not on the record. Then the stage of evidence started in that matter, and during the evidence on 15 March 1969, that son of deceased dependent Nanda Gopal, his name is Vikram, he appeared as a dependent witness number 2 before the court, and he made a statement before the court that he is also having one brother and two sisters, and he disclosed the correct names of his one brother and two sisters who are also the legal heirs of that deceased dependent Nanda Gopal. That means plaintiff came to know the names and particulars of those other three legal representatives of deceased dependent. Therefore, on the 12th August 1969, this plaintiff filed application before the court under Order 22 Rule 4 of the Civil Procedure Code, read with Section 151 of the Civil Procedure Code, for bringing the remaining legal heirs of the deceased Nanda Gopal on record. In that application, he said that it is only on the 15th March 1969 when that Mr. Vikram, who is the son of that Nanda Gopal, when he disclosed the names of other legal heirs, then only plaintiff came to know came to know of that said legal heirs for the first time, and therefore said three legal heirs may also be brought on record as a legal representative of that deceased dependent. So plaintiff made application on 12th August 1969 under Order 22 Rule 4. To that application, that widow of Nanda Gopal filed a reply on 16 September 1969 raising objection contending that now the plaintiff cannot make such application for bringing other legal heirs on record because plaintiff was prevented by the principle of estoppel, principle of res judicata and principle of waiver for making such application, another application for bringing legal representative on record. Why she gave such a reply? Because previously on 24th February 1968, that advocate for plaintiff made a statement before the court that he gave up, that is, he sacrificed the claim against other legal heirs because their names and address were not known to them in spite of his best efforts to find them. So on the basis of that statement, in this reply made by the widow of that deceased Nanda Gopal, she said that now the plaintiff is stopped from making such another application. Then the trial court has framed the issues in that matter, and one of the issues is that whether because of that statement made by the advocate of the plaintiff before the court regarding giving up his claim against other legal heirs, whether because of that statement suit has abated due to that statement. Then the trial court passed the order on 2nd March 1970. So it is a twofold order, and that order is going against the interest of both the parties in the suit, that is also plaintiff and also that legal representative of deceased defendant. So twofold order. First part of the order of the trial court held that suit had not abated. That means this order is in favor of plaintiff Naresh Chandra, but it is against that widow of deceased Nanda Gopal and one son, because they were contending that suit should have been abated. So this is the first part of the order. Trial court held that suit had not been abated. Suit had not abated. But in the same order, trial court also held that another application filed by the plaintiff to bring other three legal heirs of the deceased defendant on record, that application has been rejected by the trial court. So application is rejected. Plaintiff's application has been rejected to bring that other three legal heirs of deceased Nanda Gopal on record. And what is the reason given for rejection of that application of plaintiff's application? Because trial court gave reason that plaintiff was stopped from filing the application for the impleading of said three legal heirs because he made a statement his advocate made a statement previously before the court that they were giving up the claim against that other legal heirs. So this part of the order is against the plaintiff but in favor of that legal representative of deceased Nanda Gopal. Ultimately, suit had not abated. That was the main thing in this order. And suit had not been abated, therefore, being agreed by this order, that Srimati Kailash, who is a widow of deceased Nanda Gopal, she filed this present revision petition before the High Court. So this matter came before the High Court. So in this present revision petition before the Delhi High Court, that Srimati Kailash, who is a widow of deceased Nanda Gopal, deceased dependent, she filed this revision petition against Naresh Chandra Mishra, who is a plaintiff in the suit. So before the High Court, it was the contention, it was contended by the advocate appearing before the High Court on behalf of the petitioner, that Srimati Kailash. The advocate said that the trial court should have held that the suit had abated. Why? Because trial court refused to impede that other three legal heirs. Therefore, trial court should have held that suit had abated, because all the legal heirs of deceased defendant Nanda Gopal was not been brought on record within prescribed limitation period. Only two of them has been brought, that is one widow and one son. Widow and that one son. So it was the contention on behalf of petitioner, that is widow of deceased. So fact remains, it is a fact that the deceased Nanda Gopal died leaving behind him 5 legal heirs, one widow, then 2 sons named as Vikram and Ravi, and 2 married daughters named as Rekha and Nina. But he only brought within the limitation period only 2 legal representatives on record, that is widow Srimati Kailash and first son Vikram. But other 3 legal heirs, that is another son Ravi and that 2 daughters Rekha and Nina, they were not brought on record, and trial court refused to brought on record these other 3 legal heirs. Therefore, it is a contention on behalf of the petitioner, that is Srimati Kailash, that where a sole defendant died and only some of his legal heirs have been brought on record as legal representative of this case, then suit should be held to have abated in its entirety. So it was the contention on behalf of the petitioner, where a sole defendant died. So in our case, there is a sole defendant, Mr. Nanda Gopal, and only some of his legal heirs have been brought as a legal representative, then suit should be held to have abated in its entirety. So it is a fact in present case, those other 3 legal heirs were not brought on the record within the prescribed limitation period. Only two of them have been brought, that is widow and Vikram, one son Vikram, within the limitation period. Therefore, that advocate for that petitioner, Srimati Kailash, argued that court, it has to be held that the widow and son, that widow and one son Vikram, did not represent the whole interest of deceased Nanda Gopal, and therefore suit abated in totality. To this argument, advocate for respondent gave a reply. Respondent means your original plaintiff Naresh Chandra. That advocate for Naresh Chandra, that is plaintiff, gave a reply before the High Court that where after a diligent and bona fide inquiry regarding the legal representative of deceased party to a suit, all the known legal representative have been brought on record. All the known legal representatives have been brought on record within the prescribed period of limitation. Then action cannot be said to abate. Action cannot be said to abate if subsequently it comes to be known that there were some more legal representatives who were not brought on record because of lack of knowledge about them. Therefore, in such a case, it is the Article 137 of the Limitation Act that applies in such case, and that under that Article 137, the period of limitation is 3 years. 3 years from the date. 3 years from the date when the existence of other legal heirs came to be known. So here that Article 137 comes into picture in this case. That Article 137, it is a residuary article prescribing the period of limitation, article in this Limitation Act. It is a residuary provision regarding any other application prescribing the period of 3 years from the time that 3 years is to be counted from the time when the right to apply occurs. So it is a contention, it is argument on behalf of, it is the argument of the advocate on behalf of the plaintiff respondent that in this case Article 137 is applicable. To support his argument, that advocate for respondent plaintiff gave a reference of two cases, two case laws. One case law is reported in All India Reporter, year 1963, Andhra Pradesh, page 406, and the parties in this case, reported case, is Manem Venkata Ramaya versus Manem Munirama. In this case, the Andhra Pradesh High Court held that where there are several legal representatives of deceased dependent, then it is sufficient if all the legal representatives known after due diligent inquiry are joined within the period of limitation. If all the legal representatives known after the due diligent inquiry are joined within the period of limitation, and then a subsequent application for bringing the other person on record as a legal representative, then in such situation where some of the legal representatives have been brought on record on an application made within the limitation period, then in such situation, a subsequent application for bringing the other persons on record as legal representative is not governed by the 90 days rule, but it is governed by the limitation of 3 years as provided for under Article 137 of the Limitation Act. So it was held by the High Court. 90 days rule means it comes under Article 120 of the Limitation Act, 90 days. That advocate on behalf of the respondent plaintiff before this High Court also referred one another case, another judgment of the Supreme Court, which is reported in All India Reporter 1965, Supreme Court, page 1049. Parties in this case were Dayaram versus Sham Sundari. So in this case, the Supreme Court also held that where a plaintiff, after diligent and bona fide inquiry, ascertains who actually the legal representative of deceased dependent are and brings them on record within the time limited by law, then there is no abatement of the suit. What the Supreme Court held, where the plaintiff, after diligent and bona fide inquiry, ascertains actually who the legal representative of deceased dependent are and brings them on record within the time limited by law, then there is no abatement of the suit, because those implemented legal representatives sufficiently represent the state of the deceased dependent, and the decision obtained with them on record will bind not merely those implemented legal representatives but the entire state, including those not brought on record. So it was held by the Supreme Court. So these two judgments was referred by the advocate on behalf of the respondent plaintiff before this High Court in this case, and therefore it is observation of this in this present case of Delhi High Court. In the present case, fact shows that after the death of deceased Nanda Gopal, after the death of dependent Nanda Gopal, plaintiff Naresh Chandra filed an application within the period of 90 days for bringing on record the legal representative of the deceased, known legal representative of the deceased, then known legal representative of the deceased, and when later on during the trial, when that one son Virendra disclosed the names of other 3 legal representatives of the deceased, then when that Virendra disclosed the names of other 3 legal representatives while he was giving statement as a dependent witness before the court, that plaintiff, after coming to know the name of other 3 legal heirs, immediately filed application before the court for their implement under Order 22/4, read with section 151 of the Civil Procedure Code. Then so that plaintiff was prompt in making such an application. So he made immediately, after coming to know that other three legal heirs, then he made application to bring them on record. But the trial court rejected that application on the ground that he was now stopped from making such an application again, because that advocate for plaintiff gave a statement before the trial court that he was giving up the claim against the other legal heirs. But in this case, the High Court observed that statement made by the advocate regarding giving up the claim against the other legal heirs. He gave a statement because he was not able to know their names and address in spite of his best effort, and therefore his statement was a result of helplessness. Therefore, that statement of that advocate cannot bar again the plaintiff for making application for including the other legal heirs as soon as their names were disclosed. Therefore, it was held by the High Court ultimately that the trial court has committed a material irregularity in exercising the jurisdiction under Order 22, Rule 4, in dismissing the application of the respondent plaintiff dated 12 August 1969 for bringing other three legal heirs on record. So, ultimately, High Court has dismissed this revision petition filed by that widow of deceased Nandagopal, and that High Court upheld that. Held that trial court should not have dismissed the application made by the plaintiff, that another application made by the plaintiff for bringing that other three legal heirs of the deceased defendant. So, we have discussed this topic with reference to this limitation period, Article 137. So, we stop here. We will discuss some another topic relating to this topic in our next part of the video. Thank you.